Thank you for joining us today for the first in this year's Black History Lecture Series. I'm Jill Upson, Executive Director of the Herbert Henderson Office of Minority Affairs. Today, we will be presenting Elliot G. Hicks. Attorney Hicks is a native of Charleston's West Side. He has practiced law in Charleston, West Virginia for just under 40 years. He has taken well over 100 jury trials to verdict in the state circuit courts and the federal district courts. He was elected a fellow of the American College of Trial Lawyers, and he was also elected a member of the Federation of Defense and Corporate Counsel. He maintains the highest rating of AV with Martindale-Hubbell, and he is recognized by inclusion in the publications Best Lawyers in America and Super Lawyers. Attorney Hicks has served as president of the West Virginia State Bar Association from 1998 to 1999, the first lawyer of color to hold that position. His current legal practice is in dispute resolution, mediation, and arbitration to resolve cases that have been filed in West Virginia's courts. He attended Washington and Lee University and then graduated from West Virginia University with a Bachelor of Arts degree in Political Science in 1978. He graduated from West Virginia University College of Law with a Juris Doctorate degree and was admitted to practice law in West Virginia in 1981. Among his other community activities, Attorney Hicks served for 7 years on the West Virginia Higher Education Policy Commission, establishing policy for all state-supported colleges and universities, and served as the chairman of the Concord University Board of Governors for 4 of his 8 years on the board. In January 2019, Attorney Hicks was awarded the Governor's Living the Dream Award as a person who best exemplifies all of the characteristics of justice, scholarship, sharing of self, human and civil rights, and advocacy of peace, with a recognizable sense of civic awareness and public service. Ladies and gentlemen, the Herbert Henderson Office of Minority Affairs is proud to present Attorney Elliot G. Hicks on Black history and the legal system.
Thank you for the introduction. I'm very happy to be here. I thank the Herbert Henderson Office of Minority Affairs for letting me make this presentation to you today. You know, it distresses me that so many people in our country don't know our own country's history. Sometimes this is because they were never taught our real history. Everybody, when they tell their family's story, wants to see more heroes and fewer villains. The failure to know our history is at the root of a number of problems we suffer today. I'm going to try to do my little part to enlighten some and refresh the minds of others about the legal structure that created and over the years maintained the denial of rights of some of our citizens, particularly our citizens of color. The point is not to make anyone angry, but to reconcile and understand how we've gotten to where we are. We know what was happening in the South with the initiation and then the full establishment of chattel slavery as a permanent state of being for people of color. When we talk about chattel slavery, we mean it was not simply an indenture to pay off a debt, but it was one human being owning another human being, just like cattle. I'm going to start by helping you know what was happening in the North, where people often think that slavery did not exist. To be a fugitive slave, fleeing a life of bondage, the North was a land of freedom, or so he or she thought. The fugitives found that though they were no longer slaves, neither were they free. African Americans in the North lived in a strange state of semi-freedom. The North may have emancipated its slaves, but it was not ready to treat black people as citizens, or sometimes even as human beings. Northern racism grew directly out of slavery and the ideas used to justify the institution of slavery. The concepts of black and white did not arrive with the first Europeans and Africans, but it grew on American soil. During Andrew Jackson's administration, racist ideas took on new meaning. Jackson brought in the age of the common man, or so he called it. Working class people gained rights that they had not before possessed, particularly the right to vote. The only people who benefited were white men. Blacks, Asians, and women were not included. This was a time when European immigrants were pouring into the North. Many of these people had faced discrimination and hardship in their native countries. But in America, they found their rights expanding rapidly. They had entered a country in which they were part of a privileged category called white. Classism and ethnic prejudices did exist among white Americans and had a tremendous impact on people's lives. The bottom line was that for white people in America, no matter how poor or degraded they were, they knew there was a class of people below them. Poor whites were considered superior to blacks and to Indians as well, simply by virtue of being white. Because of this, most identified with the rest of the white race and defended the institution of slavery. Working class whites did this even though slavery did not benefit them directly and was in many ways against their best interests. Before 1800, free African American men had nominal rights of citizenship. In some places, they could vote, serve on juries, and work in skilled trades. As the need to justify slavery grew stronger, the racism started solidifying. Free blacks gradually lost the rights that they did have. Through intimidation, changing laws, and mob violence, whites claimed racial supremacy and increasingly denied blacks their citizenship. In 1857, the Dred Scott Court decision formally declared that blacks were not citizens of the United States. We'll talk more about that in a bit. In the Northeastern States, blacks faced discrimination in many forms. Segregation was rampant, especially in Philadelphia. African Americans were excluded from concert halls, public transportation, schools, churches, orphanages, and other places. Blacks were also forced out of the skilled professions in which they had been working. Soon after the turn of the century, that is the century to the 1800s, African American men began to lose the right to vote, a right that many states had granted following the Revolutionary War. Simultaneously, voting rights were being expanded for whites. New Jersey took away the black vote in 1807. In 1818, Connecticut took it away from black men who had not previously voted. In 1821, New York took away property requirements for white men to vote, but kept them for black people. This meant that only a tiny percent of the black men could vote in that state. In 1838, Pennsylvania took away the vote entirely. The only states in which black men never lost the right to vote were Maine, New Hampshire, Vermont, and Massachusetts. The situation in what was then the Northwest region of the country was even worse. In Ohio, the state constitution of 1802 deprived blacks of the right to vote, to hold public office, and to testify against white people in court. Over the next 5 years, more restrictions were placed on African Americans. They could not live in Ohio without a certificate proving their free status. They had to post a $500 bond to pay for their support in case of want, and they were prohibited from joining the state militia. In 1831, blacks were excluded from serving on juries and were not allowed admittance to state poorhouses, insane asylums, or other institutions. Fortunately, some of these laws were not stringently enforced, or it would have been virtually impossible for any African American to immigrate to Ohio. In Illinois, there were severe restrictions on free blacks entering the state, and Indiana barred them altogether. Michigan, Iowa, and Wisconsin were no friendlier. Because of this, black populations of the northwestern states never exceeded 1% during that period of time. African Americans also faced violence at the hands of white Northerners. Individual cases of assault and murder occurred throughout the North, as did daily insults and harassment. Between 1820 and 1850, Northern blacks also became the frequent targets of mob violence. Whites looted, tore down, and burned black homes, churches, schools, and meeting halls. They stoned, beat, and sometimes murdered blacks. Philadelphia was the site of the worst and most frequent mob violence, and here we see Philadelphia again. City officials there generally refused to protect African Americans from white mobs and blamed blacks for inciting the violence with their uppity behavior. African Americans and their white allies did not simply sit back and accept Northern racism. They responded to it in a whole range of ways. Black people founded their own churches, schools, and orphanages. They created mutual aid societies to provide financial assistance to those in need. They helped fugitive slaves adjust to life in the North. Combined with these actions was the constant effort to end slavery, to protect fugitive slaves, and to save free black people from being kidnapped and sold south. Some states even passed personal liberty laws to counteract federal legislation such as the Fugitive Slave Act of 1850. These protected fugitives and guaranteed some rights to African American citizens of that state. In 1857, there was a court decision of momentous importance. Dred Scott versus John F.A. Sandiford was a legal case in which the U.S. Supreme Court ruled 7-2 that a slave, Dred Scott, who had resided in a free state and territory where slavery was prohibited, was not, just because he resided in that free state, entitled to his freedom. It said that African Americans were not and could never be citizens of the United States. And the court said that the Missouri Compromise of 1820, which had declared all territories west of Missouri and north of a certain latitude were free, was an unconstitutional law, an unconstitutional compromise. That decision added fuel to the sectional controversy and pushed the country closer to civil war. Of course, the Civil War was fought in the first half of the 1860s, and despite the rhetoric of some in the South today, the northern-based government of the United States prevailed. Following the war, we amended our Constitution with the 13th, 14th, and 15th Amendments, all granting rights that had theretofore been largely denied to black citizens. The 13th Amendment to the U.S. Constitution, passed and ratified in 1865, says, "Neither slavery nor involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction." So in other words, there would be no slavery or involuntary servitude in the United States unless you had been convicted of a crime. Despite the clarity of that law, the efforts to deny the rights of citizenship continued. We had the rise of black codes, or laws specifically for black people, which were used to criminalize many aspects of everyday life for black citizens and to create harsher sentences for petty crimes. They allowed African Americans certain rights, such as legalized marriage, ownership of property, and limited access to the courts, but it denied them the rights to testify against white people, to serve on juries or in state militias, to vote, or to start a job without the approval of the previous employer in some states. An Alabama history education initiative lesson explains huge numbers of convicts, primarily black males, many of whom had been legally but unjustly imprisoned, often on trumped-up charges, were leased by governments across the South to various businesses in search of a source of cheap labor. These codes were all repealed in 1866 when Reconstruction began. But after the failure of Reconstruction, because of the refusal of the states to cooperate and the failure of the United States government to enforce those laws, and the removal of black men from political offices that they had earned by the vote during Reconstruction, Southern states again enacted a series of laws intended to circumscribe the lives of African Americans. Harsh contract laws penalized anyone attempting to leave a job before an advance had been worked off. Pig laws, interesting term, pig laws unfairly penalized poor African Americans for crimes such as stealing a farm animal. Often there was no factual basis for the charge that they had stolen anything, but yet the people in that state used the pig laws to try to keep black people from being free. The term pig law derives from Mississippi, where the theft of any property over $10 became grand larceny. The pig laws were expanded even more and with even more discriminatory laws once the Jim Crow era began. And the pig laws continued until only 5 days after the Pearl Harbor attack on December 12, 1945. The entire complex of black codes was enforced by a police apparatus and judicial system in which blacks enjoyed virtually no voice whatsoever. Whites staffed the urban police forces as well as the state militias. Examples of the laws known as the black codes after Reconstruction. For instance, in Louisiana, the St. Landry Parish Police jury established codes limiting the movement of black people. They use the word jury much as we would use county commission here today. Section 1 of the code prohibited black people from passing within the limits of the parish without a special permit in writing from an employer. Punishment was a fine of $2.50, 4 days of work on the public road, or corporal punishment. In other words, they would beat them. Section 4 required every black person to be in the regular service of a white person or former owner who would be responsible for their behavior. According to the Mississippi Department of History's historic timeline, the prison population subsequently quadrupled. The documentary Slavery by Another Name, financed in part by the National Endowment for the Humanities, estimates that 800,000 men faced the corrupt justice system, with huge numbers of those arrested, forced into involuntary servitude. In the 1850s, 99% of Alabama's prisoners were white. In the 1870s, 85% of its prisoners were black. Of course, pre-Civil War, they had no real need to put black people in jail because they were of much greater value being enslaved. Once they were not enslaved, then they filled the prisons with them so that they could use them to lease out, make money for the county and from the lease, and provide free labor to the person who was leasing them. Many have said that this system was much harsher than slavery itself, because when you had a slave, you had property that you wanted to maintain your investment. When you were simply leasing someone from the county for some kind of offense, you really didn't care what happened to them because you could always get another one. So the health of those people who were kept in that system was at great, great risk. The convict leasing system benefited by providing cheap labor across the state. Many misdemeanors or trivial offenses were treated as felonies with harsh sentences and fines. Vagrancy statutes made it a crime to be unemployed. Plessy versus Ferguson. This case arose and originated in 1892 as a challenge to Louisiana's Separate Car Act of 1890. The law required that all railroads operating in the state provide equal but separate accommodations for white and African American passengers, and it prohibited passengers from entering accommodations other than those to which they had been assigned on the basis of their race. In 1891, a group of Creole professionals in New Orleans formed the Citizens Committee to test the constitutionality of the separate car law. The committee chose a person of mixed race as the plaintiff in the test case to support its contention that the law could not be consistently applied because it failed to define white and colored races. Homer Plessy, who was 7/8 white and 1/8 African American, purchased a rail ticket for travel within Louisiana and took a seat in a car that was reserved for white passengers. In the United States Supreme Court, on May 18, 1896, by a 7-1 majority, the court advanced the controversial separate but equal doctrine for assessing the constitutionality of racial segregation laws. Plessy versus Ferguson was the first major inquiry into the meaning of the 14th Amendment's Equal Protection Clause, ratified in 1868, which prohibits the states from denying equal protection of the laws to any person within their jurisdictions. Plessy versus Ferguson gave constitutional sanction to laws designed to achieve racial segregation by means of separate and supposedly equal public facilities or services for African Americans and whites. It served as a controlling judicial precedent until it was overturned by the Supreme Court in Brown versus the Board of Education of Topeka in 1954. To say that these laws should be an embarrassment should be an understatement, but they were inspirational to someone. In 1935, Nazi Germany passed two radically discriminatory pieces of legislation: the Reich Citizenship Law and the Law for the Protection of German Blood and German Honor. Together, these were known as the Nuremberg Laws, and they laid the legal groundwork for the persecution of Jewish people during the Holocaust and World War II. When the Nazis set out to legally disenfranchise and discriminate against Jewish citizens, they weren't just coming up with ideas out of thin air. They closely studied the laws of another country, according to James Q. Whitman, the author of Hitler's American Model, and that country was the United States. America in the early 20th century was the leading racist jurisdiction in the world, said Whitman, who was a professor at the Yale Law School. Nazi lawyers, as a result, were interested in and ultimately influenced by American race law. In particular, the Nazis admired the Jim Crow-era laws that discriminated against Black Americans and segregated them from white Americans, and they debated whether to introduce similar segregation in Germany. Yet they ultimately decided that it wouldn't go far enough. One of the most striking Nazi views was that Jim Crow was a suitable racist program in the United States because American blacks were already oppressed and poor, he says. But then, in Germany, by contrast, where the Jews, as the Nazis imagined it, were rich and powerful, it was necessary to take more severe measures. Because of this, the Nazis were more interested in how the U.S. had designated Native Americans, Filipinos, and other groups as non-citizens, even though they lived in the United States or its territories. These models influenced the citizenship portion of the Nuremberg Laws, which stripped Jewish Germans of their citizenship and classified them as nationals. But a component of the Jim Crow era that the Nazis did think they could translate into Germany were the anti-miscegenation laws, which prohibited interracial marriages in 30 of the United States' 48 states. America had, by a wide margin, the harshest law of this kind, Whitman says. In particular, some of the state laws threatened severe criminal punishment for interracial marriage. That was something radical that the Nazis were very eager to do in Germany as well. The idea of banning Jewish and Aryan marriages presented the Nazis with a dilemma. How would they tell who was Jewish and who was not? After all, race and ethnic categories are socially constructed, and interracial relationships produce offspring who don't fall neatly into one box. Again, the Nazis looked to America. Connected with these anti-miscegenation laws was a great deal of American jurisprudence on how to classify who belonged to which race, he says. The controversial one-drop rules stipulated that anyone with any black ancestry was legally black and could not marry a white person. Laws also defined what made a person Asian or Native American in order to prevent those groups from marrying whites. Now, notably, Virginia had what they called a Pocahontas exception for prominent white families who claimed to be descended from Pocahontas. The Nuremberg laws, too, came up with a system of determining who belonged to what group, allowing the Nazis to criminalize marriage and sex between Jewish and Aryan people. Rather than adopting a one-drop rule, the Nazis decreed that a Jewish person was anyone who had 3 or more Jewish grandparents. We'll show you here a chart that illustrates the machinations that the Nazis went through in order to try to determine who was Jewish and who was not. You can't really read it unless you can read German and unless you can read this kind of poor copy that we have. But it does show that there was much tortured logic to their assignment of race and ethnicity, much as there was in the United States, where one drop or 1/8 or any number of other calculations of non-whiteness were used. According to Professor Whitman, the American racial classification law was much harsher than the Nazis themselves were willing to introduce in Germany. It should come as no surprise, then, that the Nazis weren't uniformly condemned in the U.S. before the country entered the war. In the early 1930s, American eugenicists welcomed Nazi ideas about racial purity and republished their propaganda. American aviator Charles Lindbergh accepted a swastika medal from the Nazi Party in 1938. Once the United States entered the war, it took a decidedly anti-Nazi stance. But black American troops noticed the similarities between the two countries and confronted them head-on with a double V campaign. Its goal was victory abroad against the Axis powers and victory at home against Jim Crow. Now let me talk a little bit about housing discrimination. Let me refer you to what I perceive as the foremost scholar of housing discrimination in the United States. I have this book, The Color of Law, by Richard Rothstein. Mr. Rothstein published this book, The Color of Law, to educate people on the housing laws and policies instituted and enforced by our own government from 1940 forward. I can't recommend this book more highly. Many of us think that the problems that black people faced ended with slavery, or that they ended with the 1954 Brown versus Board of Education decision. This will show you the lengths to which American politicians and white America went to try to disenfranchise black people, to keep them from living in the same areas as white people, and to keep them from acquiring wealth. He wanted to educate people on the housing laws and policies instituted and enforced by our own government from 1940 forward. In 1947, a man named William J. Levitt developed single-family tract housing using federal funds. These became known as Levittowns. Built as affordable housing for World War II veterans and their families, the first Levittown was built in suburban Long Island, New York. Similar developments for whites only were built in Pennsylvania and New Jersey between 1952 and 1963. These Levittowns became the model for real estate developers across the country, and they helped establish a pattern of racial discrimination in housing that persists even today. When I look at some of the pictures of Levittowns, and let me show you one of those pictures, the pattern of those houses is very much like what we see in Ordnance Park in St. Albans. All these houses were almost exactly the same. They were built in a concentrated area, and they wanted a homogeneous group of people living there. Returning World War II veterans spurred a population and housing boom that was driven in part by benefits from the GI Bill. The economic demands of the post-war boom and the burgeoning civil rights movement led to conflicts over discrimination in housing, jobs, and education. The Federal Housing Administration instituted policies that reinforced patterns of segregation, routinely denying low-interest loans to non-whites. The experience of fighting for freedom in Europe and then returning to a country where discrimination and opportunities were limited fostered discontent for returning black GIs. The legacy of post-war economic discrimination contributed to the wealth gap between whites and non-whites that we see today, and our own government sanctioned the discrimination in the GI Bill that prevented black GIs from getting the low interest rates for housing and housing in places that would appreciate in value. Instead, black people were, a term you've probably heard before, redlined in places where they were not, where they were all bundled together, sometimes near undesirable factories, and in places where the property values would be unlikely to increase. One of the most important factors that have contributed to the wealth gap that we understand is current between white families and non-white families is the housing policies, were the housing policies at that time. These policies endorsed redlining and discrimination in sales, discrimination in financing, and discrimination in homeowners insurance. It's reflected in the unequal rates of home ownership even today. From the 1930s to the 1960s, through the 1960s, black people across the country were largely cut out of the legitimate home mortgage market through means both legal and extra-legal. Chicago whites employed every measure from restrictive covenants to bombings to keep their neighborhoods segregated. Their efforts were buttressed by the federal government. In 1934, Congress created the Federal Housing Administration. The FHA insured private mortgages, causing a drop in interest rates and a decline in the size of the down payment required to buy a house. But an insured mortgage was not a possibility for black people. The FHA had adopted a system of maps that rated neighborhoods according to their perceived stability. On the maps, green areas, rated A, indicated in-demand neighborhoods that, as one appraiser put it, lacked a single foreigner or Negro. These neighborhoods were considered excellent prospects for insurance. Neighborhoods where black people lived were rated D and were usually considered ineligible for FHA backing. They were colored in red. Neither the percentage of black people living there nor their social class mattered. Black people were viewed as a contagion. On the cover of Mr. Rothstein's book, you see some of these maps that have the colors, that have the red colors and some of the green colors that allow them to be more desirable. Again, I recommend this book very highly. Redlining went beyond FHA-backed loans and spread to the entire mortgage industry, which was already rife with racism, excluding black people from most legitimate means of obtaining a mortgage. Now let me talk about one very, very current example of laws used against people of color, but it doesn't necessarily state that it's against people of color. One of Richard Nixon's top advisors and a key figure in the Watergate scandal, John Ehrlichman, told Harper's Magazine writer Dan Baum during a 1994 interview for an article on another subject that the war on drugs was created as a political tool to fight blacks and hippies. The Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and black people. Nixon's policy chief Ehrlichman said, "You understand what I'm saying? We couldn't make it illegal to be either against the war or black. But by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities," Ehrlichman said. "We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did." Ehrlichman's comment is the first time the war on drugs has been plainly characterized as a political assault designed to help Nixon win and keep the White House. It's a stark departure from Nixon's public explanation for that for his first piece of legislation in the war on drugs, delivered in a message to Congress in 1969, which framed a response as a response to an increase in heroin addiction and the rising use of marijuana and hallucinogens by students. However, Nixon's political focus on white voters, the silent majority, is well known, and Nixon's derision for minorities in private is well known from his White House recordings. Ehrlichman died in 1999, and his 5 children questioned the veracity of the account, saying, "We never saw or heard anything from our dad that was derogatory about any person of color," they wrote in a statement that they provided to CNN. The 1994 alleged quote that we saw, this is again the children speaking, we saw repeated in social media for the first time today, does not square with what we knew of our father, and collectively that spans quite a bit of time with him. Nonetheless, sometimes people mold to the character of their boss. And we've seen that today, and we see that from that time. Just to sum this up, let me go over a few of the historical laws that the United States government has used to try to change and get away from discrimination. The United States government has practiced race discrimination in many forms and in various forms over time. But there are some laws that have been well-intentioned to try to combat the effects of racial discrimination. Among those laws are the Civil Rights Act of 1964, Title VII, which it was the Civil Rights Act. It was a very significant piece of legislation when it was enacted in 1964 and continues to protect individuals against discrimination. The Act has many anti-discrimination provisions, including Title VIII of the Civil Rights Act of 1964, which prohibits employment discrimination based on race, color, religion, sex, and national origin, including limited English proficiency. It prohibits discrimination against people who can't speak the language well. The Equal Credit Opportunity Act granted all applicants an equal opportunity to obtain credit through the anti-discrimination provision. The Equal Credit Opportunity Act prohibits creditors from discriminating against credit applicants on the basis of race, color, religion, national origin, sex, familial status, age, and the applicant's use of public assistance. United States Code, Title 42, Chapter 21 of the U.S. Code prohibits discrimination against persons based upon age, disability, gender, race, national origin, and religion, among other things, in a number of settings, including education, employment, public accommodations, federal services, and more. Chapter 21 is where a number of federal acts related to civil rights have been codified, including the Civil Rights Act of 1866, enacted immediately after the Civil War, the Civil Rights Act of 1964, and the Civil Rights of Institutionalized Persons Act. The Fair Housing Act prohibits discrimination in the sale, rental, and financing of housing on the basis of race, color, national origin, religion, sex, familial status, or disability. The Voting Rights Act of 1965 bans the denial or restriction of the right to vote and forbids discrimination in voting practices on the basis of race and color nationwide. The Disaster Relief and Emergency Assistance Act provides for equitable and impartial relief operations without discrimination on the grounds of race, color, religion, nationality, sex, age, or economic status during an official emergency or disaster. So you see, we do have a number of laws that were enacted to try to counteract the huge wave of resistance people of color have fought against to try to become full citizens of the United States. Our history is bad, but we continue to be a work in progress, and we try to be better. I hope you'll do further research on all of these topics that I brought up, and I hope you'll learn for yourself exactly what has happened in our country so that we can have a springboard to move forward to try to do better. I thank you for your attention, and I look forward to speaking to you on other topics later and talking with you about these very matters. I believe that discussion is something that's needed, and we need to come together to try to have truth so that before we can have reconciliation. Thank you.
That was a very informative presentation by the esteemed Elliot Hicks, and we thank him for leading our 2021 Black History Month lecture series. Thank you for watching, and please look for our next lecture in this series entitled Black History and Economic Development with Thaddeus Breckenridge. We look forward to seeing you again.